Take
Yeah.
it away.
Hi. Hi, everyone. I'm Lauren, the Non-Human Rights Project's Communications Director. I am Zooming in from Portland, Oregon. And I'm going to be posing some questions to Steve today about our appeal in Happy's case. So Steve, do you want to say hi?
Hello, how are you? For those of you who may know me, if you notice, my hair has not been cut in 6 months. It's rapidly heading down to my shoulders. So eventually I'll return to normal.
It's very professorial. It worked. Okay, well, we'll just get started. Steve, I hope you could start with discussing where we're at in the process. It's been a long road, an interesting road. So could you just briefly tell everybody where we're at?
Yes, in January or in February, Justice Tuitt in the Bronx Supreme Court had issued a very sympathetic opinion to us, and but said that she thought that she was bound by a case that we had litigated involving chimpanzees now 6 years ago, and that was the only reason that she thought that though she wanted to, she couldn't rule in our favor, and so we have now appealed that. Our brief was filed in about a week or two ago, and the other side now has almost a month to answer. I think they've indicated they're going to be seeking an extension, which we won't object to as a matter of courtesy, of another 30 days. So somewhere in mid-September, the other side should file their brief, and at that point we have like 10 days to file ours, our reply brief to theirs, and then at that point we're waiting to be called for oral argument. It should be either in October or November, though these days you never can tell what's going to happen, and you also can't tell, we can't tell whether we'll be able to argue in person, which we would prefer to do, or whether we'll be relegated to arguing through a Zoom call.
Yeah, thank you. And two follow-up questions with that. Just for people who aren't lawyers, could you explain a little more what a brief is, what an appellate brief is in particular, and what you mean when you say the other side will have an opportunity to reply? Like, so in other words, why do those briefs matter?
Sure. Well, the brief is the way that the Non-Human Rights Project and the Bronx Zoo communicate with the court. So we're each filing a brief. It's a maximum of about, I think, 13,000 words. And we go first since we're the ones who appealed. And actually, we worked on our brief for 4 months. And now we're very, very happy with it. But we did work on it for 4 months. Then we filed it. They then have almost 30 days. They'll probably take almost 60 days in which to draft and file their reply. And then we're allowed under the rules 10 more days to reply back to them, addressing whatever issues they raised in their brief. At that time, the First Department in Manhattan, which is where we are appealing, then we'll read and understand what it is that we're trying to say, what they're trying to say, and then we'll set up oral argument. And I hope we'll then argue about what we have talked about in our briefs.
Right. Thanks. And could you talk a little more about what those 4 months are like what exactly you and the rest of the legal team are doing? Like what goes on in that 4 months? I know it gets pretty intense, but our supporters don't always see that from the outside.
It has gotten intense. You know, we almost 7 years into this project, we remain highly confident that the facts that we're able to marshal are in our favor. In fact, in Happy's case, as in all of our cases, the other side has never once been able to file an affidavit, which is a sworn testimony that contradicts any of the facts that we put in about the nature of elephants. And in fact, in our brief, we specifically commented on that and compared it to the fact to the Sherlock Holmes story, Silver Blaze, in which it was significant to Sherlock Holmes that a certain dog didn't bark. And we said, that's the same thing that's going on with the Bronx Zoo. The Bronx Zoo is part of the Wildlife Conservation Society. They're a billion-dollar organization. They have elephant experts on their staff. They probably have access to elephant experts all over the world. Yet, not a single elephant expert not even a trainer of an elephant, filed an opposing affidavit that put any of the facts that we put in about elephants into dispute. And we put in hundreds of facts. We had five experts who are five of the top experts involving elephant cognition in the world, and they put in an enormous number of facts that will go uncontroverted. We're also very confident about our legal arguments, and what took us 4 months is that we've now seen over the last 6 or 7 years which legal arguments the judges seem to have difficulty understanding sometimes, or it may kind of pluck some emotional cord in them. We've seen that might cause them to want to reject our arguments, not on the law because it makes them nervous. It causes some kind of an emotional issue in them that we have seen arise again and again. So all of the lawyers were involved in dozens and dozens of conversations on the phone, on Zoom, about how we can present our arguments in a way that the judges can most easily understand and that are the least likely to cause any kind of negative emotional reaction on their part. So even though we've now been doing it for many years, we decided that we really wanted to focus on being as clear as we could, as simple as we could, as uncontroversial as we could. And we're really proud of the brief. We think we did a really great job.
Yeah, I agree. And when you say uncontroversial, could you say a little bit more about what you mean by that?
Uncontroverted. It meant that
uncontroverted.
Yes. So every fact that our experts had put in at the trial level has to be taken as true, because the Bronx Zoo was unable to controvert, dispute, any of the facts about the nature of elephants that we put in. So therefore, they have to be taken as true.
Right. Would you be able to detail in a brief way the arguments in the appellate brief? Yeah.
Well,
I know that's a lot to ask in one Zoom call.
Let's see. The words detail and in a brief way contradict each other. Let me see. Well, we have.
Or what I could ask it a different way.
Okay.
What was the primary challenge the legal team faced, aside, like legally speaking, like leaving aside the emotional component as you just described? Like another way to put that might be thinking about justice to its decision. Like where did she end up, and then what position does that leave us in as we make our argument to the First Department?
Well, Justice Tewitt wrote this very, kind of extraordinarily sympathetic brief to us. Justice Tewitt wrote quite an extraordinarily sympathetic decision where she said again and again that we had persuaded her that Happy should not be in a zoo. She noted Judge Fahey's argument from the Court of Appeals, his concurring opinion in our chimpanzee cases, in which he said that a chimpanzee probably is a person, is not a thing. She agreed that the same thing applied to elephants. That Happy probably was entitled to bodily liberty, but it's just that she felt that she was not able to have us win because she is a lower court, and there had been an intermediate appellate court in 2014 that had said that in order to have rights, an entity has to be able to assume responsibilities or duties as well. And so one of the main things that we've done in our brief is to really focus on that, because that's simply false. No court has ever held that. That was the first court in the history of English-speaking courts, for hundreds and hundreds of years, who had ever said that, and it's simply wrong. And so we've kind of very carefully, but in ways that we hope the judge will the judges will understand, have explained to them why their reasoning was simply wrong. Part of it could be attributed to the fact that that they relied upon what's called Black's Law Dictionary for the definition of person. And when we went back to look at Black's, it took us months and months to find the specific edition that they were talking about, and also the specific sort of source that they had relied upon. We found that that Black's had actually misquoted the secondary source. For example, one of the big fights in that case was, in order to be a person, do you have to be an entity who can bear both rights and duties, or are you a person if you can bear either rights or duties? So we would argue that in order to be a person, you just have to be an entity who can either have the capacity for rights or the capacity for duties. The court was saying, no, in order to be a person, meaning that you have the capacity, for legal rights, you have to be an entity who can bear both rights and duties. And one of their major sources was Black's, and they cited a very old source that it took us months to find, and we finally found it in the Library of Congress. And when we found it, we realized that Black's had changed it from saying you can be a person if you're subject to rights or duties. They had changed it to rights and duties, and so the court itself was wrong because it relied upon Black's, who had incorrectly translated the words and changed rights and duties to rights or duties. Interestingly enough, when we were in front of the First Department last time, we were concerned that they were going to make the same mistake, and we filed a motion asking them to look at the correspondence that we had with Black's, because when we brought it to the attention of the editor-in-chief of Black's, within 3 hours, he wrote back and said, "Oh, we're really sorry, we'll fix it next time." So we then sent an email, we filed a motion with the court saying, would you look at our correspondence? You can see that Black's admitted it made a mistake, and we don't want you to make the same mistake. And believe it or not, the court denied our motion. They refused to look at our correspondence, and then they made the same mistake. And then those kinds of mistakes in law can perpetuate themselves. For example, the Connecticut case that we lost also relied on that case, and they also ignored the fact that Black's had simply made a mistake, and they became the second court to perpetuate the same error. So that was one of the things that they got wrong. We're trying to explain that to them again. Another issue is they kind of related to that, and which we're trying to explain again, is that they had the idea that in order that rights somehow depend upon what philosophers and political scientists would call the social contract, and they relied upon a kind of an obscure law professor out in California who himself does not understand what a social contract is, and he made the argument that in order to have a social contract, or that you have to be able to be a person. And so what we're arguing is that let's see, no, actually he said that entering into a social contract makes you a person. And however, what social contract theory says is that you're born a person, and when you enter a social contract, it makes you a citizen. And so he mixed up citizen and person, but the court got that part confused as well. So the decision that Justice Tuitt relied upon because she felt she had to is wrong in two, and actually more ways than that. So we've already seen that several courts have not understood what we're saying, and also they haven't even understood what some of the philosophers who filed amicus or friend of the court briefs are saying about it. So we went over it again and again, and other parts of it again and again, to try to make it more and more simple, so that the judges would be able to understand what our arguments are. Because we had found that arguments that we thought were actually quite clear, the judges did not seem to grasp. So that's really much of what we spent over the last 4 months, was trying to refine it and simplify so that the judges could understand what we're talking about.
And great, I think that was relatively brief. Could
I was
you,
worried I've been going on. I went on too long, but go
no,
on.
I mean, it's important. Could you talk about the role that the amicus briefs play in that process too?
Yes.
Yeah, just last, some people watching this may know, just last week, Lawrence Tribe, Harvard law professor, filed an amicus brief in support of Happy's legal personhood and right to liberty and entitlement to habeas corpus. And then we just learned actually that a group of philosophers and two more habeas corpus scholars filed amicus briefs in support. So yeah, so maybe you could explain what an amicus brief is and why does it matter, and why does it matter that these particular individuals submitted them in support,
Sure.
if that's not too much.
Amicus curiae briefs mean friend to the court. And so someone who's not a party to a case, but who is interested in the outcome of it, can then ask the court if they would allow them to file what's called an amicus curiae brief. And what that does, it allows the interested person who's not a party to give his or her opinion as to how the judge should rule, or how the court should rule, and why. So the three folks who are filing amicus briefs in support of our work now, one is a consortium of North American philosophers. Number two is Harvard law professor Lawrence Tribe, and three are two habeas corpus scholars. So they also actually filed amicus briefs when we were involved with our chimpanzee cases and wanted to have the Court of Appeals understand what we were saying. They also wanted the Court of Appeals to understand what they were saying. So they had also filed amicus briefs, and Judge Fahey, in his decision in the Tommy the chimpanzee case, had actually relied upon them. And so then when we decided to appeal to the First Department, Justice Tewitt's decision, they again said, we want to file amicus briefs. And we said, go ahead, file amicus briefs. And so the same three are doing it again. And they're important. Number one, the group of philosophers are very important because what they're explaining to the court is not only did that one court make legal errors, but it also made philosophical errors and political science errors. And they go into for example, the issue of social contract, and they show where that like obscure professor, they show all the ways in which he's wrong. They talk about what person is in philosophy. And so they give a whole different point of view than we do, because they're arguing from a philosophical and a political science point of view. But sometimes the courts, either knowingly or not, find themselves moving from law into philosophy or political science. So, we're not experts in that, and they are experts in that. So it helps the judges better understand what the underpinnings might be to their legal findings. So we're really pleased that most of the philosophers who signed on to the chimpanzee brief and who were involved in it, and they also worked on it, I think for a couple months, they're now filing another brief, and they did it last week, I think. Second of all, Harvard law professor Lawrence Tribe had also filed a brief. I saw his amicus brief from last week. It's somewhat different, and it deals specifically with issues that arose in Happy's case as opposed to the chimpanzee case. Lawrence Tribe is a very well-respected law professor. And we are hoping that, like Judge Fahey did in the Court of Appeals, the judges sitting on the First Department will also recognize that Lawrence Tribe is a smart guy, a highly experienced person. He may be, or at least he was at one time, I don't know if he still is, he may be the lawyer who's argued the most cases in front of the US Supreme Court. He's written books about constitutional law. He understands what's going on, and he has something to say, and we'd like to have them listen to what he says. The third thing are two habeas corpus scholars, because our case is about habeas corpus. We're arguing that the elephant Happy is being imprisoned at the Bronx Zoo, and we're using the common law writ of habeas corpus. And these professors are experts in the area of habeas corpus, and so they can bring their expertise to bear. They can talk about the background of habeas corpus, the meaning of habeas corpus, how it developed, because we only have 12,000 words. So we're very busy trying to figure out how we condense our arguments into 12,000 words, because that's one of the things we do. By the way, during those 4 months, we start out with a brief that might have 20 or 25,000 words, and we have to argue really word by word by word. Do we need this word? Do we not need that word? Is there a way that we can say something more simply or condense it? So we get down to 12,000 words, and it helps to have habeas corpus scholars who have their own word limit, but they're just focusing solely on the issue of habeas corpus, and can give and kind of have the luxury of giving a background that we don't.
Actually, that reminds me of another question. To those among our supporters who might be intimidated by the idea of reading these documents, whether amicus briefs or appellate briefs or the decisions, like, do you have any advice for them, or what would you say to people who are a little nervous about that but are interested?
We hope that we have written it in a way that any of you should be able to understand it. We understand that appellate court judges are very busy. They don't have a huge amount of time to read our briefs, like they don't have a huge amount of time to read anyone's briefs. And so we're trying to write it in a simple, easy to understand way, although as lawyers, sometimes we forget, how to us something might be simple, but someone who's not a lawyer, it isn't simple. But we think we have it down so that any of you out there should be able to read our brief. It's in plain English, simple English, and we think you'll be able to understand it.
Yeah, and I think for my part, because I'm not an attorney, obviously, what still shines out from them is, at the core of this is an autonomous being who is being imprisoned. Like, Happy's story is at the forefront of it. Like, it's not just the legal arguments, if that makes sense.
That's exactly true.
Yeah. So hopefully that will give some people kind of a window, an angle into it, to not be intimidated. But okay. I'm going to ask a couple questions that came in from our supporters. And
okay.
A little while after that, we're going to open up the chat window for some more. But one question that came in from Rose via email is, she wonders, why is this so hard? What she means by that, I think, is...
I know what she means.
Yeah, one would think that it would be obvious, that Happy doesn't belong at the zoo. Like, why does it take such intense litigation to free her? And then, so maybe you could talk a little bit about that.
Sure. Well, the reason it's hard is that almost all the judges all the judges who we see in the United States have grown up in a background, like in a culture, kind of their cultural wallpaper that they haven't even thought of, is that non-human animals are legal things who don't have the capacity for rights. They didn't learn anything to the contrary in elementary school or high school or college or law school. They didn't learn anything to the contrary as lawyers or judges. And then all of a sudden they run into our arguments, and they've simply never encountered them before. And we've always understood that, which is why we never expected to win the first few times out, even the first few years out. Now, in fact, we're in year 6 or 7, and we're actually quite ahead of where we thought we would be at this time. We've always believed that one of the reasons we chose the writ of habeas corpus was because we've always believed that if we keep bringing cases in front of the same judges, that then they hear our arguments again and again, that eventually they'll begin to understand what it is we're talking about, and not feel that they're biased against us. And the kind of bias they have is generally not an explicit bias, it's an implicit bias. It's the biases that we all have because that's how we grow up. In fact, the idea of implicit bias is very much around us in 2020. If you look at the Black Lives Matter, you look at issues of racism. Much of the issues around racism is not that people are explicitly racist, but they're implicitly racist. They've grown up in a racist society. We have racist kind of ideas, but we don't even recognize, that they are. And we've understood that we've always assumed that judges were implicitly biased against us, and that it was going to take some work to be able to have them be able to grapple with their bias, and that assumes that they wanted to grapple with their bias. And as the Black Lives Matter folks make clear, many people don't really wish to grapple with their bias. And this was brought home to us when Judge Fahey on the Court of Appeals wrote a very supportive opinion. Essentially said that the courts in New York that had ruled against us were all wrong, and that our arguments were right. Now, this was the third time that we had brought a case before Judge Fahey. The first time we brought Tommy's appeal to him, he voted to not hear the appeal. When we brought Kiko's appeal to him, he voted not to hear the appeal. Then the next time we brought both Kiko and Tommy's appeals together in front of him, that was the third time in 4 years that he had seen our arguments. And he came right out and said it. And he said that he had been struggling. He used the word, "I've struggled with your arguments, and I struggled with the fact that I voted against you, 4 years ago." And he essentially said, "I've now changed my mind. A chimpanzee is not a thing. A chimpanzee is probably a person." And we believe that there are judges, we're hoping that there are judges out there who will indeed begin to struggle with their own concerns, their own biases, their own very human reaction at something that's not only entirely new, but actually is different than what they had grown up with and learned in law school and worked with as a lawyer and a judge. So we think that's one of the reasons why once we get into the state of New York, 7 years later, we're still filing lawsuits in the case of New York. And we probably will continue to file lawsuits in the state of New York for some number of years, because not only are we persistent, but there's an educational component of what we're doing. There's kind of an anti-bias component of what we are doing. And we understand that. And so that's really one large reason. And there are, as we travel around the world, and we also see what judges are doing in other countries, sometimes we see the same thing in those countries, but sometimes we also see judges who look like Judge Fahey, who except they didn't have, for some reason, that implicit bias, but they had this idea that somehow it was just morally wrong. It's morally wrong to imprison an elephant or chimpanzee or whale or a recent opinion in Pakistan, a crocodile, in India, birds, horses. So there have been cases coming down in India, in Pakistan, in Colombia, in Argentina, and sometimes they go the way that Judge Fahey went, and sometimes they go the way that the judges who rule against us go. And so it's not just in the state of New York, but it's really worldwide that judges are beginning to address this as our brother and sister lawyers in other countries, and some of whom we're working with. For example, we're working with lawyers in Israel. We'll be bringing a lawsuit in 2021 in Israel, another one in India, perhaps one in Pakistan. And as we all kind of move together towards embracing the idea that non-human animals can be legal persons, they can have the capacity for rights, and our argument switches from can a non-human animal have a right to what kind of right should any specific species have. And that's one of the things that Judge Fahey said, that in order to determine whether or not a being should have the right to bodily liberty protected by a writ of habeas corpus, you look to the intrinsic nature of the species. And that's why we put in so much evidence about what the intrinsic nature of our client is as a species.
Right. Could you comment actually on the, how do you see the interplay between the, between Happy's case in the New York courts and the Islamabad High Court decision? Some people may know that Happy's case was referenced in that decision. So there's almost like a back and forth there, it seems. I just wondered how you see that working. And I think some people too have asked, and as we celebrated the Pakistan decision, could that help Happy?
Yes.
Yeah.
Well, there's been an interesting kind of toing and froing with us so far and the Pakistani case. As Lauren says, the judge in Islamabad who ended up ordering Kayvon and an elephant and other non-human animals freed, but Kayvon was then ordered sent to a sanctuary in Cambodia. He did reference both our chimpanzee cases and Happy's case. Then, interestingly, Lawrence Tribe, then referenced the Pakistan case. That was last week. And then 2 days later, the judge issued in Pakistan another case in which he referenced Larry Tribe's reference of his case.
Right.
And it's clear that the judge in Pakistan is closely following. And in fact, we know he is because we've heard from him. He's closely following our litigation and especially Happy's case. And so some of the arguments that judge in Pakistan made, just like judges in Argentina have made, or Colombia have made, or India have made, we have put before the American judges. But there you might have a whole other set of problems. There are some U.S. judges who somehow feel that all they're supposed to do is look at U.S. courts, that if you're not an American judge, then what you have to say really isn't worth paying attention to.
The courts outside the U.S. haven't had that same sensibility, it seems like. They're much more willing to pay attention to what judges in other countries
They are. And some judges, I think, in the U.S., we're going to run into them because there are more and more cases being decided outside the U.S. And we also make it clear to the court, we're not saying that you're bound by something that a judge in Islamabad or Delhi, or Buenos Aires, says, but we think you should look at the reasoning. We think you should look at the emotions behind it, the knowledge behind it, because the judge in Pakistan, for example, was talking about COVID-19, was talking about the environmental factors. These things aren't just Pakistani; it's also happening in New York City, and so. We're hoping that some judges, and we know they will, judges are going to begin, I think, to understand that this is a worldwide problem, that the issues that are coming in front of the court are similar, and that they should give kind of a studied, careful studying of what those judges are saying. They may or may not agree with them, but I don't think that it's appropriate for a U.S. judge to say, well, just because that judge is in India or Pakistan, especially, by the way, India and Pakistan are actually common law countries. We all have an England heritage, and so we're all working, in English, in common law. And the least we can do is listen to each other and see whether what we're saying makes sense.
Yeah, thank you. And one thing I wanted to say too on the question of litigation just inevitably taking a long time, we simultaneous to the litigation, we have grassroots advocacy going on in an effort to put pressure on the Bronx Zoo and the Wildlife Conservation Society outside the courtroom. And so we hope, whether it's by court order because they decide to do the right thing as a result of public pressure, and the undeniable facts about who elephants are and what they need to thrive. so that's just so people know. And then there's a role for, anyone listening to play in helping with the grassroots advocacy. And we did get a question from Cheryl Ann via email about how to help. And I think Mickey's going to paste in a link to the chat window with our latest action alert. So, because I recognize that some people might feel sort of powerless listening to the details of the legal case, because there's nothing, anyone can do. Like, we might not even be able to go into court to support because they might be virtual arguments, but there's always ways that people can help. So there's that. And I just had one other question for you before we do the chat window.
Okay.
Which is, it comes from Mary on Facebook, but it's a question we get a lot, which is, and it's going to require perhaps some speculation on our part, but why does the Bronx Zoo refuse to let Happy go?
Well, I obviously I can't read their minds, but I do have my ideas. One of them is that the world has changed. The world has turned out from under them. They don't understand that they're dinosaurs. They're living anachronisms. Their ideas about zoos simply are not part of what people think anymore. They're not part of the population. They have these ideas that when I was growing up is what all zoo directors thought, and now they're just kind of verging on the bizarre. So we don't think, for example, when they file affidavits in court about various things, we don't think they're lying. We think they're just delusional. In fact, there was a similar case involving the LA Zoo about 10 years ago. And I think the judge may have used that word. He said there were all these higher ups in the LA Zoo who were testifying, and he said he thought they were deluding themselves. They're delusional. They view themselves as kind of being like saintly people who are helping non-human animals, and what they're doing is tormenting them. And they're imprisoning them, but this is how people thought for centuries, and they still think that way. And they don't understand quite yet that we are the future, and they are on their way out. That's number one. Number two may be, non-human animals, especially charismatic megafauna like elephants. People want to pay money to see them. Part of it is just a purely pure economics, that they think that they can make money by displaying an elephant, and and that is just unforgivable.
Right. And I think we can say too that their arguments don't withstand any pressure, no matter what angle you take, legal, scientific.
No, we win the scientific arguments. We win the moral arguments. We win even in front of Justice Tuitt. We actually won the legal arguments. We won everything. And I think she said the word "alas," or something like that, where she said, I have to rule against you, even though it was very clear that she did not want to. She actually said that we had persuaded her. In fact, I think she said we were, quote, extremely persuasive, unquote. And just the fact that we were in front of Justice Tuitt, I think, for 13 hours, the fact that a trial court judge gave us 13 hours to argue the case allowed us to really, put in our facts, put in the legal arguments, and pick a fight with the other side, because we want to be able to fight with the other side, because we believe that the other side has nothing that they can say that can beat us. So we want there to be another side. We want them to be arguing. In fact, we want the best lawyers in the United States to be making the best arguments that they can make on the other side, because we are highly confident that we can beat them.
Right, and that's what makes possible what I might say is the unique NhRP persistence. Like, never give up, because we know we're right. We know that history is on our side and the law is on our side.
Also, the very fact that we are persistent allows us to perform the educational function I was talking about. We now realize, or at least sometimes I realize, what it must have been for a judge in 2013 when the Non-Human Rights Project just kind of parachutes in from nowhere and comes in front of judges, 3 judges in 1 week, the first week of December, saying, we want habeas corpus for a chimpanzee. And what were they supposed to do with that? Well,
Right. Didn't one judge wish us luck, Judge Size?
Judge, he did, and he did. I mean, some of them, one of them was totally unsympathetic. Like, what are you doing in my courtroom? The other one said, good luck. I just can't rule in your favor on habeas corpus. And then the third one said, I don't want to be the first one to make this leap of faith. So you have this kind of, plethora of different sorts of arguments, and they've kind of continued to expand. Sometimes we're treated quite rudely by judges in the courtroom, and sometimes the judges say, you can just look at them and you can see that they're beginning to understand what it is we're saying. And I can't emphasize too much the fact that that our arguments, we are part of the future. The way we treat non-human animals now is beginning to disappear. It's part of the past, and that means that we have to redouble our efforts and really stamp it out.
Yeah, and it must be part of the future for these animals to remain with us, I think, because models of conservation that depend on imprisoning individual animals, it's not going to work. It's not enough. We need more fundamental change.
That's another thing that the judge in Pakistan said. Not only was he talking about COVID-19, but he said, we're not here on this world. If non-human animals have to be here with us, and if not, we're going to be wiped out as well. We're all going to go down together. Right. So in some ways, judges have to begin to learn that there's this kind of environmental component on top of our rights component.
I'll stop asking questions now to give people in the chat window a chance to. So I think Mickey's going to pull some questions from there for you, probably.
Yeah. Yeah, we've got a lot of good questions coming through, so we'll try and get through as much as we can. Going off of what you both were talking about in terms of, the judges and their different rulings, Wendy asks, why does it serve the judge not to rule favorably?
Say that one more time.
Why does it serve the judge not to rule favorably?
Well, there could be a couple of reasons. First of all, especially judges who might be elected, as in New York, some of them may not want to be the first person or the second judge and the third judge in New York to rule that non-human animals have legal rights, because eventually they're going to have to run for re-election. So that could be one possibility. We don't know. It just could be. Other judges simply want to keep their head down. They don't wish to be on the front page of the New York Times. They just want to kind of do their jobs, day in and day out. And some of them are likely, concerned about the effects of their ruling. One of the major arguments that the other side has, even the Bronx Zoo, they brought people in who were arguing to the judge, and this is not unusual for us, but this lawyer actually argued that if the judge orders Happy free and sent to a sanctuary, then the New York dairy industry would be destroyed.
I remember that. Yep.
And there might be a judge who's worried that maybe she's going to destroy the New York dairy industry, and not that, well, okay, I won't say any more.
Okay, so we've talked a lot about, corporations are technically persons in the eyes of the law. So is a river in New Zealand. I think that's, a myriad of other things. Where Sky and Susan both ask, where does that argument lie within ours? Like, how does that impact ours, or does it at all?
I think it does. Though we don't understand why, and we're learning a lot as we litigate year after year, because there are some things that we assume the judges know and they don't, and so we have to then continue the educational process in that way as well. One of the things that we're surprised that judges don't seem to kind of deeply understand is that person and human are not synonymous. They're not synonyms. And then we have to explain that there were hundreds and hundreds of years in which many human beings were not persons. Some, slaves or women or Native Americans, or they simply weren't persons. So that's one way of trying to explain to a judge that being a person and being a human are not synonyms. A person is an entity with the capacity for rights. So we also say, at the time, say where some humans were not persons, some things that were not human were persons, like corporations, like the state of New York, like the United States of America. They're all persons for various reasons. So, and then we begin to go deeper, saying that in New Zealand, for example, a national park is a person, a river has been made a person. In India, the Ganges River has been a person. In Colombia, the Amazon rainforest is a person. In India, the Indian Supreme Court said that all animals were persons as a matter of statute and constitutional law. That was in 2014. So we try to, and of course we talk about corporations and ships, as well. But it's all part of a campaign to make judges really understand that a person is simply an abstract idea. It's an entity. It's an entity that has the capacity for rights. And that if the judge says that our client should have the capacity for rights, and then that makes her a person. By the way, we also point out that the so-called pet trust statutes in California, because we're about to file lawsuits in California, and also in Colorado, in Connecticut, New York, there are pet trust statutes that make our companion animals and others, they make them beneficiaries of a trust. And as a beneficiary of a trust, that means they have a right to the corpus of the trust. And then once you have a right, that makes you a person. So we have been arguing now for almost 7 years to the courts in Connecticut and New York. We say, look, our chimpanzee clients, our elephant clients, they already are persons. We've made them beneficiaries of a trust to the degree that the so-called pet trust statute applies to our chimpanzees or our elephants. They already are persons. But even if they aren't, the legislatures of New York and Connecticut have said by enacting a pet trust statute that certain companion animals are already persons. So they've already made non-human animals persons, but in those two states. And remarkably, the judges don't address the argument. They don't tell us that we're wrong. They don't tell us that we're right. They simply ignore them. You won't see any discussion of the pet trust statutes in the judicial decisions, even though we pounded home in oral argument. We pounded home in our briefs. Our client is already a person. Now we're asking simply for a second right, the right to bodily liberty protected by a writ of habeas corpus, on top of the first right she has, which is the right to the corpus of a trust. But the courts do not deal with that. And sadly, the only reason I can think that they might do that is they actually don't have a reason why we should lose. They don't have anything to say, but for whatever their own personal reasons are, those judges don't want us to win. There was one judge, Justice Jaffe, who dealt with Hercules and Leo's case, and she was the judge in the HBO film about our work, and she did briefly talk about that and recognize that some non-human animals are persons within the state of New York through the pet trust statute, but then she didn't apply it.
Right. Yeah, interesting. So a couple of people are curious to know what the Bronx Zoo, what their arguments are. Why do they want to keep Happy? Why, I think they've said things like they've claimed that she's aggressive towards other elephants, can't be socialized. How do we, what do we say about that?
There is, our experts, say clearly, there isn't anything wrong with Happy that the Bronx Zoo has not caused. And there isn't anything wrong with Happy that is not going to be fixed once you remove her from the Bronx Zoo and put her into a sanctuary. So that kind of argument is ridiculous. And there's no one who's really qualified to make the argument, whoever does for the Bronx Zoo. In fact, no one from the Bronx Zoo ever even filed an affidavit that said that they'd ever met Happy. So anyway, that's one of the arguments they make. Another argument they make is that if the judge releases Happy, then the New York dairy industry will be destroyed. Another argument they make is that not that the that the decision of the third department, who said you have to be able to have duties in order to be able to bear duties in order to have rights, they can't argue that that's right, because it's not right. They simply argue that it binds the lower court. And we've twice, Justice Jaffe's decision and now Justice Stewart's decision, both of them were very sympathetic to us, and both of them said, but alas, I'm bound by this other decision. So that's one of the things that we've done in the 4 months in which we were writing the briefs, is that we put that right in our sights. We are attacking that decision every possible way we can. There's nothing about it that is correct. Virtually every word of its legal discussion is simply wrong, and we've tried to make it as clear as we possibly can, that everything that court said was wrong, and that can happen, and it did. And the other side, the zoo, doesn't really argue that it was right. They just argue that it is, and therefore it binds the lower courts. That's why we keep trying hard to get into the higher courts, where they won't be bound by that decision. And the only judge that we've been able to get in front of that was in a court higher than that court was when we went to the Court of Appeals, and Judge Fahey then said that court is wrong. So in fact, Judge Fahey is the only high court judge in the United States who has ever opined on whether our theories are correct. And he said that they are, and that the lower courts who have ruled against us, they're the ones who are wrong.
Yeah, right. So I think we have kind of talked about this in the past, but maybe you could give a little brief explanation as to why we're doing this through a writ of habeas corpus.
Sure. Habeas corpus means you have the body in Latin, and it's called the Great Writ, and it's something that judges take very seriously. So that's one of the reasons we want to take it, that we use it, because it's called the Great Writ. When a judge sees that a habeas corpus case in front of her, then that is a tip-off that someone's claiming that she's being imprisoned against her will. So that's one of the reasons. Another reason is that there are technical reasons why we are doing it. The issue of standing, that plagues animal protection lawyers. It plagued me when I was an animal protection lawyer. It plagues environmental lawyers. The idea that an entity has to be injured in order to be able to file a lawsuit. So, for example, if I see a car hit you, and you decide not to file a lawsuit for damages against the driver, I can't bring that lawsuit on your behalf because you have standing, you've been injured, but I wasn't injured, therefore I don't have standing. So in order to bring a lawsuit, you have to, number one, be a person, which means you have the right to even have standing, and then you have to be injured. So you have to be an injured person. Now, usually lawyers don't have any problems dealing with having injured persons as their clients. In fact, every time a human walks into their office and complains that she's been injured, you have an injured person. The problem is that non-human animals are terribly injured. Happy's being terribly injured, but she's not a person. She can't file the lawsuit. The Non-Human Rights Project, we are a person, we are a corporation, but we haven't been injured. And so the way we get around that is perhaps uniquely in Anglo-American jurisprudence, you don't need standing in order to bring a writ of habeas corpus. Presumably, one of the reasons is because it deals with people who are being imprisoned against their will. Obviously, if you're being imprisoned against your will, the jailer is not going to let you out of jail to go in and seek a writ of habeas corpus. So a third party can. Another thing is the courts for hundreds of years have wanted to encourage people who see that someone else might be imprisoned against their will to come in and challenge that imprisonment. So another reason is if you and I say sign a contract, and I think you've breached the contract, I would then bring a case for breach of contract against you. If I lose, and I then brought a second case for breach of contract against you, you would be able to put up the defense of what's called either res judicata or claim preclusion. And that means in lay language that you've already sued once, you've lost, and you can't sue again. You only get one bite at the apple. But again, there is an exception in habeas corpus. The claim preclusion or res judicata just flat out do not apply to habeas corpus cases. You can keep bringing habeas corpus cases until the cows come home. And in some of our cases, for example, in New York, we saw one person who finally won on the 5th writ of habeas corpus that he brought. Now, there are ways that the courts have developed that will say you can bring the writ of habeas corpus, but we might not have to look at it very carefully unless you've given us some kind of a new fact or a new kind of argument. And we have been thrown out of court when we thought we did give a new fact or new sort of argument, and the court did not agree with us. But we did not lose as a result of issue preclusion or res judicata. We had the right to keep bringing the case. And that's, I think I may have said, one of the reasons that we chose habeas corpus was that we want to keep bringing the cases, so we keep going in front of the same judges. And like Judge Fahey did, the third time perhaps or the fourth time that a judge sees our arguments, he or she may start to view them in a different way. So that's just one, two, three reasons why we use writs of habeas corpus. Oh, there's another one, which is habeas corpus is supposed to go really fast. Judges understand that someone could be kept against her will, and they don't like that. So instead of having a case that can go on for, as many cases do, for years, habeas corpus cases are so-called summary writs. They move really fast. They move so fast, for example, that if we lose a habeas corpus case in that the judge did not issue the writ of habeas corpus, we can immediately appeal, and we have lost habeas corpus cases by having the judge not agree to issue the writ on the same day we file it. So we walk in on a Thursday and we walk out of court, we didn't get our writ, we've already lost. That allows us to not have to wait 2 or 3 or 4 years for our case to finish, because it is finished. We can immediately begin the appellate process.
Yeah. So I think we are almost out of time. So I might just ask you, Steve and Lauren, if you have any last things you want to mention about Happy's case or anything there.
Happy's case, I think, is a very sympathetic case. I mean, as far as I'm concerned, all of our cases have been, but it's the first elephant case that we brought to an appellate court. One of our hypotheses that somehow judges may view elephants different than chimpanzees. Maybe chimpanzees are uncomfortably close to human beings, and it gives them the willies. We can't really tell. We have all kinds of hypotheses about why judges do things that they probably shouldn't be doing, and we spend a lot of our time scratching our heads and talking about that, trying to understand why a judge is doing something that doesn't seem to make any sense to us. So one of our hypotheses was that maybe chimpanzees, look like us. They're too human, and maybe if we brought a lawsuit on behalf of an elephant, that might cause a judge to be able to not feel as creepy as they might feel when they're dealing with a chimpanzee. Now, for all I know, none of what I said is true, but all we can do is keep generating hypotheses as to why we might not win our cases. So we'll be looking at that. We'll also be looking to see whether if we lose, and we're hoping we don't, but if we lose in the first department, the next thing we're going to do is try to figure out why we lost and then present our case to the Court of Appeals, which is a high court. Judge Fahey should be there. We keep our fingers crossed that he will agree with us on elephants the way he agreed with us on chimpanzees, and that there'll be at least 2 more judges who will agree that as Judge Fahey said, this is an important issue that you can't ignore, and the High Court of New York should hear this case. So with any luck, if we lose in the first department, which we don't plan on it, but of course it can happen, then the next stop will be the Court of Appeals, and there we hope that they will allow us to argue before them, I hope, in person.
Yeah, and I would just add that, like, in addition to the action alert we shared earlier, an always important way that people can help is to tell happy story in whatever way makes sense to you, whether it's on social media or in an actual conversation or sharing a news story, because part of what we're trying to do too is get everyday people to see the injustice of Happy's situation, to not see what we're used to seeing, which is an elephant standing in a pen as a monorail goes by and thinking that's normal or right. So to see Happy differently in that way, and to make visible what is legally invisible. So keep sharing Happy's story. That helps a lot. So that's it for me, though.
Great. Thank you both so much. And thank you everyone for listening in and tuning in. We'll have the recording of this up hopefully by tonight, and stay tuned for details on our next Zoom, which is happening August 5th with Catherine Doyle, who works at PAWS, and she'll be talking about what sort of life Happy and also Minnie, and all imprisoned elephants and animals could have in sanctuary. So
thanks, everyone.
thank you so much.
It's been a real treat for me. Thank you for supporting the work of the Non-Human Rights Project. We rely upon you for everything, and we're very grateful.
Thank you. Have a good day, everyone.